With the court's blessing again, my lord, may I recall the matter SS-163 of 2015, State versus Mia and 4 others.
Thank you.
There has been discussions between the stakeholders, and same has been relayed to Mr. Alexander. I will leave him to address the court further as to what the instructions are insofar as the accused is concerned after the discussions.
Yeah. Before I get to you, Mr. Alexander, could I go back slightly and invite Mr. van der Merwe? There's just an aspect I would like to get clarified by him. Thank you. Thank you very much. Mr. van der Merwe, as you were making your submissions, at some stage you indicated that it wouldn't be proper if they appeared in shackles. Is that correct?
That is indeed so.
Right. That simply begs the following question. If they are not,
oh my lord, I think the problem that arose is that they did.
Just a second. Right?
They did appear in front of you in shackles. And what we said and what the case law says, that brings about certain presumptions.
No, I'm with you. I'm with you.
So,
but the question I'm asking,
yes,
in wanting to know for completeness sake, I'm asking if they do not appear in shackles.
Yes, my lord.
What is the position? Will it be proper? That's what I want to know.
Yes, it would be proper because
Thank
every person
you.
should not appear in front of you because, well, before you and or any other presiding judge.
No, that's no. I just wanted to know that for completeness sake. Thank you, Mr.
May I just add something, my lord? I've indicated to you that accused number 3 has not been shackled.
I beg yours?
I indicated to you that accused number 3 has not been shackled, but I see that position has now changed after the tea adjournment.
Is he shackled?
He's now shackled.
Thank you, Mr. van der Merwe. Mr. Alexander.
My lord, I confirm with my learned friend for the state has indicated to my lord, as directed by my lord, we have entered into discussions. There are some of the most senior officials from the Department of Correctional Services, Zonderwater, present in court, and we did discuss the matter with them. I thank them for that. The aspect as to consultations have been sorted out. We are now entitled to private consultations. That's been sorted out.
Just a minute.
Downstairs and in court.
Just a minute. Right?
I previously indicated that I had a problem with, I wasn't being permitted private consultation. That has been remedied. I am, as of yesterday afternoon, I'm now being permitted private consultations with Mr. Krejcir, which is as it should be. I'm not going to go into that. I thank my learned friend for the state as well for alleviating that problem which we have been struggling with.
Right, thank you.
The documentary aspect has also been resolved that I can present court documents to Mr. Krejcir, which they'll be taken to prison, but they'll be vetted by the prison officials. They aren't there's no attorney-client privilege that attaches to them per se. There'll be court documents which you can take and study, obviously, to get written instructions. That was problematical. That has been resolved.
Thank you.
The handcuffs issue, in other words, the shackles around the wrists, that issue has been resolved. My Lord will note that Mr. Krejcir, if I may just ask him to stand, my Lord.
For the court to see.
Yes, my Lord will notice, that he is no longer shackled. However, my Lord, which brings me to the very next aspect, I'm going to ask Mr. Krejcir to indicate to my Lord, he's wearing a belt. I'm not too sure what the name of it is.
Just a minute.
In short, I'll call it it's a shock belt.
Just a minute. Just a minute. What do you call it?
I refer to a shock belt.
belt.
I'll ask Mr. Krejcir to indicate to my Lord, there's an apparatus on it. Just show us.
Yeah, no.
There's an apparatus on it which is now on his hip. It looks like a Velcro belt. I'm not too sure. I've never had the displeasure of having to wear one, my Lord, so I'm not too sure what we should term it. It's called a shock belt. Apparently it works on the electrical impulse. If you misbehave, you'll be shocked. I think that's the simplest way to put it. And I say that as lightly as I can. My Lord will notice that the handcuffs are generally, which would be attached to Mr. Krejcir's wrist, are attached to this belt.
Yeah.
And his hands have been loosened from them. So for my application will be pertaining to the belt that he's wearing, as well as the fact that Mr. Krejcir is shackled around the ankles. This is what we've agreed between the state and ourselves, what the application that we would bring. May the accused please be seated, Your Worship.
Yeah, by all
Thank you,
means.
Worship. Thank you, Worship. My Lord,
Just a second. Right, if I could, before you go very far,
thank you.
ask you a similar question. You were indicating and showed the court the belt that you described. If the belt is not there, is it in order?
The belt, my Lord, yes, the belt
Is
and
that
the,
what you're saying?
Yes.
Is it the gist of your application?
correct, the belt and the shackles around the legs, the ankles. I believe in line with the case law, which was quoted to my Lord. I'm not going to repeat it
All right, fine.
to my Lord. Justice will not only be done, but also seen to be done. Such an eloquent expression, my Lord. I don't know if I've answered my Lord's question. May I proceed, my Lord?
No. All right, fine. You may proceed. Please do.
My Lord, as I said, I'm not going to repeat what Mr. van der Merwe has really posted.
Yeah, I heard
the case law is quite clear. It's very simple. Section 35(3) of the Constitution guarantees, subject to Section 36, which deals with the limitation of rights, certain rights to an accused person. And the relevant one here, I believe, is H, to be presumed innocent. Of course, to remain silent and not to testify during the proceedings, but to presumed innocent, which I believe attaches to what Mr. van der Merwe has placed on record. It's a perception. As well as subsection 5.
Okay, fair enough. If I may ask you once more, you are referring to a perception, and if the perception is not there, the perception that you're referring to, if it is not there,
Well, my Lord, the perception, if the perception is removed,
yes,
that's what my Lord is saying. If the belt and the cuffs around the legs are removed, then the perception is not there.
yeah, no. I thought the perception that you were referring to had something to do with other aspects other than the aspects that you had mentioned. So the perception that you're referring to relates to what you have just addressed. Could that be correct?
The right to be presumed innocent? Yes.
I'm aware of that. That I have had. Are you specifically in respect of that referring to the shackles and the belt?
Correct.
Okay, thank you.
Correct. My Lord, do I need to take it further? Can I leave my Lord's hands? I could go on. The case law is already before my Lord. My Lord is aware and more than competent enough to rule in this matter.
Thank you.
Thank you, my Lord.
Right, Mr. Glover.
As might please the court, my lord. How I so wish we were arguing the merits of the case by now. However, I agree and accept that we are in a constitutional era, and in so doing, we have to abide by the Constitution. So the accused have the right to bring whatever application they need to bring to court, so as the court to deal with it. Firstly, my lord, I need to respond to this issue of accused number 3 this morning.
Yeah, just a second. Right, thank you.
Prior, when the submissions were made by Mr. Van der Merwe, I, for one, I'm not sure about the court, got an impression that perhaps the state is giving an impression to this court that if he's not in shackles, then everything is good. Now that he's brought today without shackles. After the court adjournment, it's then again indicated to the court that indeed he's now in shackles, creating an impression that the state perhaps is playing games with this issue of shackles. It has been made aware to the accused this morning that the shackles that were supposed to be put on him,
You're referring to number 3 specifically?
Number 3 specifically, were not in a working condition. Hence, extra shackles had to be arranged. And during the court adjournment, same was brought from the police station to assist in this regard. Hence, he is in shackles. He has always been in shackles all the time. It was only this morning that he was not, as per the reasons now advanced. Now, coming back to the submissions by both Mr. Van der Merwe and Mr. Alexander. My lord, this is now I beg to be correct, the 5th day. We were in court on the 9th, on the 3rd, we were in court on the 4th, we were in court yesterday, and we're in court today. Only today that an application is made for these shackles to be removed. Not on the very first day before this court. The basis for this application is that a perception may be put differently. This court might have a perception about the character of the accused before court. If I understand the submissions by Mr. van der Merwe with the case law that has been quoted to your Lordship, which submissions have been seconded by Mr. Alexander. Basically, it boils down to perception that this court might have, and of course, the rights of the accused. If that was paramount from the onset on the accused's mind, one would have at least expected that on the first appearance before your Lordship, everything is done not to create this perception. Now, the matter comes to court on several days, and then on a specific day, it is indicated to the court, you have been seeing this. Now a perception can be created. Officers of the court as well as the accused forms part of an administration of justice, including the court. If this, I resubmit my lord, was of paramount importance, it could have been brought to your court's attention on the very first day. Why wait and create the impression and then argue after and say, you have seen it? You might have this impression. It boils down to the intention to bring this application in the first place. However, moving forward, the case law that has been quoted by my colleague, it's fortunate that same has been quoted in subsequent cases. I beg leave to hand in a case law wherein all that Mr. van der Merwe has submitted was discussed in this case. And judgment thereto was given. May I further submit with this question of perception? It is my respectful submission that in any given circumstance in court wherein the word perception comes to the fore, the courts have said in numerous case law, the perception must be real. I will make an example wherein an accused applies for a recusal of a presiding officer, quoting a perception. Such must be real. There must be something upon which that perception is substantiated. Now, from day number one, the court has seen the presence of correctional services personnel in this court. I have no idea and cannot put it in the court's mind as to what implications did it make in the court's mind that there are members of correctional services here, not your ordinary police. The court is made to sit for 4 days to see what is happening in court with the presence of personnel from correctional services. And nothing is brought to the court's attention that we don't need this. It might create an impression on the lordship. It's only on the 4th day that we are told, beside the shackles, look at the court. There are personnel from correctional services. If I were to argue for the other side of the coin. We are living in an era where what happened in 1958 and 1961 and 1985 is totally different to what is happening today. I will make an example. There are certain cases that are in court, not only in South Gauteng, all over South Africa, of which there will be members of the media who will then make notes or take photographs or video material and broadcast it out there for everyone to see. Now, Judge Daba is sitting in his own comfort at home, watching the news, and he hears about the matter of State versus Cliff Alexander. He's an accused. Something is said about Mr. Alexander in this news. And then 2 years down the line, the Chief Justice said, Mr. Traba, Judge Traba, go and do case X, wherein now State versus Cliff Alexander is an accused again. Now, there's a perception that could have been created to Judge Traba when he was watching his news in the comfort of his home about Cliff Alexander. Now, Judge Traba must then say to the Chief Justice, I'm not interested because I've got a perception about Cliff Alexander. This is the era we're living in, not the 1965, 61, or 85. This is the era we're living in. We have to understand in which era that we're in right now. Hence, there's been a lot of public debate, even in Parliament, that we need stronger judicial officers. Because some of the things that are happening in our era are inescapable. Can it be said in this court that the mere fact that they were in shackles? Point number one, the court has been informed on numerous occasions. The accused are in custody, there is no bail. One counsel can stand up and say, you see, the issue of the court being informed that there's no bail can create a perception that there's something wrong with that accused. I'm just making an example. That the fact that we inform the court that there's no bail, it means this person can escape. That's why bail was refused. Anything can be said. Is that a real perception? I beg to differ, my lord. Yes, in this case which I've quoted to your lordship, of M.A. Kubega versus the state.
You're referring to the case that you've just handed
I just handed in.
Yeah.
All of this has been discussed. All the case law that Mr. Van der Merwe raised have been discussed in this case. And I agree that the court discourages this kind of exercise. But your brother, Bertelman J., on the 24th of April 2012, said the following in the same judgment.
You taking me to paragraph?
That will be paragraph, the second page, my lord, from line 7. That is the second page of the judgment, not the front one. The second page of the judgment, my lord.
Yeah, I'm there.
Perhaps I can start from line 3. This court has on a number of previous occasions pointed out to various officials of the Department of Correctional Services that this practice is unacceptable. That is now shackling and handcuffs and all of that. It is in conflict with the fundamental values of our Constitution, as it constitutes a gross invasion of the dignity of the individual concerned. It goes on further to say, only in those cases where there is a very real danger of assault taking place or an attempt to escape being made, or for other extraordinary reasons, would there be some excuse for infringing the dignity of the persons who come to court to do their business. May I also take the court to...
Just a second, if you could bear with me.
As a court, please.
Right, you may proceed, sir.
Thank you, my lord. May I also take, my lord, to the last page of this judgment? It reads from the line 1 on page 29. I trust that it will not be necessary and that the Department of Correctional Services will finally heed what our courts have said repeatedly, namely that it is highly undesirable that any person be brought into court shackled, in prison gap, in leg irons or otherwise restrained. If there is a real danger that the failure to apply to these restrictive measures may lead to violence or an escape, the department must make prior arrangement with the Director of Public Prosecutions to either effect a stronger police presence or deal with the matter differently. If there is no other way other than to restrain the accused, this must be brought to the court's attention prior to the start of the proceedings, and the accused must be heard on this issue. After your brother Judge Wesselman read all the case law and quoted the relevant paragraphs as Mr. Van der Merwe has done in this judgment, he said, at the end of the day, only in those cases where there is a very real danger of assault taking place or an attempt to escape being made or extraordinary reasons, there should be shackled. And he says, the correctional services people must then bring that to the attention of the DPP, that there is no other way to deal with the issue other than to deal with this, but that should be brought to the court's attention. Right from the onset, it was indicated this is an extraordinary matter. It's clear from both parties. The court has also been indicated, look at the presence of security personnel inside court. I'm mindful of the fact, my lord, that I should not make submissions or bring evidence that might taint the character of the accused before your lordship has had any evidence. Safe to say, there are extreme security measures that needed to be taken into account insofar as this case is concerned. It does not only goes to accused number 4 or number 1 or number 2, all of them. Your lordship has been given an opportunity to study the indictment. Same is in possession of the court. I need not go further to say how the state intends to lead its evidence, insofar as these accused are concerned. Hence, it became prudent that for these security reasons, it will not be proper to differentiate one accused against the other. All of them must be shackled. I also need to bring this to the court's attention. The idea was to handcuff as well as put leg irons on all the accused. After certain discussions, some of which also include cancer, against some of the propositions made by the Department of Correctional Services in view of this judgment, we came to an understanding that handcuffs should be removed. The court has been informed of that on numerous occasions. What does logic tells me? Let's put it vice versa, my lord, so that my submission can hold water, perhaps. Let's agree the state and the defense agreed we are not going to put leg irons but put handcuffs on the accused. Let's make that submission. One would think, other than running away with your legs, because your movement is not restricted, what else can you do with your legs if your hands are cuffed? Are you not more of risk if your hands are cuffed than not uncuffed? Because of what you can do with your hands than with your legs. Common sense. However, the state said, let us remove the handcuffs, but at least restrict them insofar as movement is concerned, in view of these extreme security measures that has to be taken against the accused.
What is being restricted?
Now the movement is being restricted by putting the leg irons, but the hands are free.
Okay.
Logic will then dictate, my lord, that there's more that they can do with their hands than they can do with their legs. However, the state considered, insofar as these security measures are concerned, though we need to put them in place, but let us not handcuff the accused. It is therefore my submission in this regard that, my lord, I do not want to give evidence or lead any other evidence because I don't want to create the perception, which I submit now is not there or is not real. However, there are extraordinary reasons why the accused come to court with leg irons. And same has not only been indicated to the DPP, same was indicated to counsel. That this is the position and these are the reasons why all of this is happening. Hence there has been numerous discussions in that regard.
Is it then my understanding that you saying this has sufficiently been explained to the office of the DPP and the council?
And council.
Thank you.
Thank you. Coming to the issue of the belt, It was indicated what the accused, or accused number 4, seems to have difficulty in the belt being there. And same was discussed with the members of...
maybe before you proceed, you will recall something was said about the belt with regard to misbehaving or something like that. Do you remember that?
Yes, according to what Mr. His understanding of why the belt is there, that was his understanding.
Yeah.
Yes, ma'am.
I see. So it is not exactly what the belt is all about.
It's for security measures, my lord. That's all I'm informed, is for security measures.
Okay, just a minute.
What Mr. Alexander said, my lord, I'm not aware of. The issues raised by accused number 4 insofar as this belt is concerned was then discussed with the members of correctional services. Such discussion yielded a certain arrangement, which arrangement was then given to counsel. Mr. Alexander.
Just a minute.
As a court proceeds, ma'am.
Is it the same understanding that you referred to a little earlier, which was communicated to the office of the DPP and counsel?
That is correct, but
a similar arrangement.
The issue of the belt was only raised this morning.
Oh, I see.
By Mr. Alexandra. And fortunate enough, the senior members of the correctional services were present today. And then the state then requested a minute to discuss these concerns that Mr. Alexander raised with the members of the correctional services. Same was discussed, and then a proposal was then brought back to Mr. Alexander that the belts need to be there, but it will be made as comfortable as it can for the accused, in view of the concerns he raised. However, the application...
Just a second.
As a court,
the discussion you're referring to was the discussion between the members of the correctional services officials and the state.
And the state, that's correct. I need, my lord, to actually indicate that the concerns raised by counsel, I specifically made it a point that all parties concerned, including now the correctional services personnel, be present when Mr. Alexandra was raising these concerns. So they heard what the concerns are insofar as this belt is concerned. I'm not going to get into other issues because there's common understanding.
Right, at the meeting?
At the main thing.
Okay, fine.
Concerns were raised by Mr. Alexandra, and then we requested time to go and discuss it in private, the concerns that he has raised. And after these discussions, then communication was made thereof to Mr. Alexandra insofar as the proposal is concerned, which includes inter alia that the belt will be made as comfortable as possible for the accused without it being removed. My submissions insofar as the shackles are concerned goes along with this belt as well, my lord. Perhaps lastly, my lord, the issue of the shackles and the handcuffs in relation to accused number 4 was at some stage brought to the court's attention. And the court was promised that same will be discussed amongst the parties. And the parties will then revert back to the court insofar as what agreement or arrangement can be made. Same indeed happened, and the discussion yielded this particular agreement that the handcuffs will be removed on accused number 4, but the shackles will remain, the leg irons that is. The court was not informed at that stage, by accused number 4 in particular, that I am giving you, my lord, this is the agreement between the parties. However, we will come back later and say there's a perception. We are saying to you, we agree with this. Let the leg irons be there.
Okay, just a second. Is it then my clear understanding that an agreement was reached, namely that the handcuffs would go? That's 1. 2, shackles would remain.
Insofar as accused number 4 is concerned.